Hello, I'm Joshua Rosenberg, and this is the second in a new series of podcasts that I'm calling A Lawyer Talks. I'm talking to you from the London offices of a newly created global law firm with nearly 4,000 lawyers. A&O Sherman was founded last month with the merger of two long-established legal practices, one UK-based originally and the other from the United States. A&O Sherman says it helps corporate clients with their most complex, multi-jurisdictional matters, but it's also helped the parents of Harry Dunn, a teenage motorcyclist who died nearly 5 years ago after a traffic accident in Northamptonshire. This month, a coroner found that his death was caused by a collision with a car driven by Anne Sacoolas, an American woman who just emerged from a US air base and then drove instinctively on the wrong side of the road. Anne Sacoolas had diplomatic immunity and she was allowed to leave the United Kingdom, although she subsequently appeared in court remotely and received a suspended prison sentence for causing death by careless driving. I'm talking now to two of the lawyers who've helped Harry Dunn's family without charging them a penny, and perhaps you'd like to begin by introducing yourselves.
Certainly. I'm Andrew Denny. I'm a partner here in the London litigation practice of A&O Sherman. I head up the firm's UK public law group, which acts for clients in both challenging decisions of public bodies and sometimes acting for public bodies and defending such challenges. But I also head up the firm's human rights working group, which coordinates the firm's pro bono work on human rights. It's the combination of those two things which led us to the work for Harry and his family.
And I'm Frances Beddoe. I am an associate in the team with Andrew, so the London disputes team at A&O Sherman. I've only been at the firm for 5 years, 2 of which were as a trainee, so I'm still relatively junior. But I've been involved in a number of pro bono projects since I joined the firm, including this case and other strategic litigation around the Rwanda challenges, where we represented the UN Special Rapporteur on Trafficking at the Court of Appeal last year.
Frances, you mentioned pro bono work, and Andrew, this is something which a lot of firms do. Just what is pro bono work?
Well, the idea is, I think, that as lawyers, we're acutely aware that we, I think, have a duty to give back and to use our skill sets to aid those who wouldn't normally have access to justice. And access to justice is a key part of our pro bono goals. And it's about using our time to work for clients who are deserving of help. And of course, we don't charge for it.
Frances, I'm sure there are many people listening to this who'd be delighted to get a firm like yours acting for them. You have to be very selective.
Well, I think it depends on the nature of the pro bono matter. We do a lot of legal advice clinic volunteering work where people who are applying for family reunion in the UK, for example, or who have a drop-in query about employment law can get one-off advice on the night. But certainly a long strategic litigation matter involves a lot of time and resources. And so we just want to make sure that our work goes to helping the people who most need it.
Andrew, there was this terrible accident. Harry Dunn was killed. And the first that we heard about it was after Anne Sacoolas, the woman who was driving the car that was in collision with Harry Dunn's motorbike, was allowed to leave the country. Can you explain that to me to begin with?
Certainly. The police had questioned Anne Sacoolas, but their understanding was that she had the benefit of immunity, and therefore there was no attempt to prevent her from leaving the country, which she duly did. That conclusion that she had immunity was the subject of a judicial review challenge, both to the Foreign Office and against the police, which led to a court decision that refusing the challenge and determining that she did in fact have immunity. We got involved in the appeal of that decision. That appeal was then put on hold because there was a criminal process ongoing. And that criminal process was the next step. There was an obvious issue there that she was not prepared to come back to the jurisdiction, and ordinarily the defendant has to be present in order for a prosecution to proceed. But the Crown Prosecution Service did take quite an innovative approach here, as did the courts, and provided for her to appear virtually and enter a plea of guilty to a charge of death by careless driving in the end. And so that was the next step. And finally, the final step has been, while the criminal process was ongoing, there couldn't be a coroner's inquest, but that inquest was then the next step in the process, and that has just concluded recently.
Frances, why was it so important to the family to see her in court?
The way that they've described it is that if this had happened in any other circumstances to any other family involving any other driver, then that family could expect British justice to see the process through, and that other driver may be convicted, they may not be, but that there would be a process that was followed. And the family felt very strongly how unfair it was that, because of the very unusual circumstances of this tragic incident, they were being denied the access to that process as a whole.
Did you explain to them the purposes of diplomatic immunity, why states give immunity to people on their territory?
I think that was obviously a key part of the judicial review, the purpose behind diplomatic immunity. We weren't involved in the judicial review during at the High Court stage, but I imagine that would have been formed a key part of the discussions with the family at that stage.
And it was just such an anomaly. Obviously, we never got an answer on appeal as to whether the FCDO had correctly determined whether Anne Sacoolas did have diplomatic immunity, but we know that her husband, Jonathan Sacoolas, would not have done. And we felt, and I know the family feels, that that just cannot possibly have been right, or the intention of those who put the arrangements in place at RAF Broughton. So I think that loophole was something that made the denial of justice feel even more painful, because had another person been driving, then this never would have happened.
It was clearly a mistake. I mean, if Jonathan Sacoolas had been driving, he would not have had immunity. That was the agreement between the United States government and the United Kingdom government. Somebody overlooked the immunity for the spouse of somebody working at the base.
And certainly, I think the family's sense is that there's been a number of missions around road safety outside a lot of these bases in the UK where we host US personnel. I don't think driver training was really considered very seriously until it has been raised in the family's campaign. And similarly, there have now been a number of recommendations made by the DFT following a national road safety the Department of Transport following a national road safety review outside US bases. So I think the family's campaign, and obviously the really tragic loss that they have suffered, has shone a light on an area that previously may not have been given enough attention.
And that's really one of the advantages of an inquest, that the coroner can make recommendations, although there's not really any way of enforcing those recommendations apart from publicity, I suppose.
Correct, but I think that's where the parallel campaign, very effective media campaign, and the family has come in, that they've picked up what the coroners had to say on these points and used it to raise awareness of these issues. In the end, there has to be a political solution to these issues, not just, of course, issues of road safety, but issues of, for example, ambulance delays. And in order to get that political solution, you have to raise awareness.
Andrew, can you give me some idea of how much work this has involved? How much partner time, how much associate time, how much firm time? Can you give me some idea of what it involved?
Well,
we've been acting for the family for, I think, 4.5 years now.
3.5 years.
3.5 years. Thank you, Frances. And over that time, we've had the involvement of 3 partners. I think about the core team's been about 6 or 7 associates, a number of trainees, but we've also involved our officers worldwide. In the context of the judicial review, for example, we were able to use the worldwide office network to do research on the issues coming out of the judicial review, including as to immunity, and get input from all of those different jurisdictions. So overall, it is, yes, involved probably thousands of hours.
And thousands of hours is hundreds of thousands of pounds, isn't it? And can you give me any idea, either of you, of what this would have involved?
Well, we don't tend to keep track of the monetary amount because we don't see it in those terms. We try and treat pro bono cases in the same way as cases for commercial fee-paying clients and try and do the very best we can for the client. And that obviously involves the dedication of a significant amount of time.
How did you get involved in this particular case? Why did the firm take that on?
It came in originally via one of the counsel team on the Judicial Review, who's an A&O alumni, who asked us to get involved at the appeal stage of the Judicial Review.
Just to interrupt you there, the Judicial Review was a challenge against the Foreign Office?
It was originally a challenge against the Foreign Office and against the local police force. But by the time we got involved at the appeal stage, it only was a challenge against the Foreign Office. Effectively, it was a challenge to the determination or the decision by the Foreign Office that Anne Sacoolas did have diplomatic immunity. I note in your introduction you said she did. That remains theoretically. That we have, of course, the divisional court decision, but that was subject to an appeal, which wasn't pursued in the end because of the way that the criminal proceedings panned out.
And if this were to ever happen again, which God forbid it does, that loophole, if it is indeed a loophole, has now been firmly closed. So the government has made it very clear that family members are included in the waiver that was previously agreed for members of the US mission working at RAF Croughton.
As I recall, when there was an agreement between the United States government and the United Kingdom government, the UK said that people working at this airbase would not have diplomatic immunity because they were going to be driving from Northamptonshire to London all the time, and it wouldn't be right to exempt them from the road traffic laws. But that waiver of immunity did not apply to their spouses, and that's why Mrs. Sacoolas was able to claim immunity, although, as you say, that was challenged in the courts. Is that right?
Yes, that is right. And had the appeal gone ahead, one of the key issues in dispute would have been whether or not an express waiver of immunity was required for family members under the Vienna Convention, or whether actually immunity for family members was contingent on the existence of immunity for the members of the mission.
And just to be clear, the limitation of the immunity of employees was only in relation to acts outside their employment. Hence, as you say, the driving back and forth from London, they wouldn't be immune for that. And that was part of the agreement between the US and the UK on that point.
I remember this litigation in the courts, but I don't think I was aware that your firm, A&O as it then was involved. I mean, you didn't really do very much high-profile publicity for your work at that time.
Yes, I think when you're doing pro bono work, you need to be conscious of what your motives are. And our primary motive here was really to help the family. And I think you need to be wary of just using it as a platform to promote yourself. And we're always very conscious of that when we're doing pro bono work. We don't refuse to talk about it unless there's a client confidentiality issue. But it's not something that we necessarily will shout about if we feel that that may not be in the wider interest, in particular, of the client. And here, as we've discussed, there was a very active and very effective campaign going on behalf of the family to get justice for Harry, but also to try and ensure that this sort of thing wouldn't happen again. And we were very wary of not cutting across that campaign by shouting about our involvement.
Francis, I remember that the family wanted Anne Sacoolas to return to the United Kingdom and face justice. And then we heard that the Crown Prosecution Service was considering bringing a prosecution against her, even if she didn't return to the UK. And I was mystified by that. I didn't think that was possible, but it was possible. And again, there must have been a lot of law involved in all of that.
Well, that wasn't something that we were directly involved in. It was obviously a decision by the CPS to pursue a virtual trial. But I can say that the family was certainly always a priority for the family that she faced the British justice system in whatever form that took. And the CPS were willing to be very innovative about what form that could take in these circumstances.
Very innovative because, in fact, as far as I recall, it was the first time you'd ever had a criminal charge decided by a court with the defendant never having been in the jurisdiction.
I'm aware, certainly, that it was quite groundbreaking from that respect. And I know British justice places a lot of emphasis on the presence of the defendant. I wonder, with obviously the intervention of COVID and the proliferation of online trials and virtual hearings, whether we've moved away from that principle somewhat.
The law has been changed to allow a trial to take place remotely. And as you say, that was something introduced because of COVID and then made permanent. So I suppose we may see more such cases, although obviously we don't want to see any more tragedies like this. But nevertheless, it is interesting, isn't it, that it's going to be possible for people to be tried and convicted without ever stepping foot in the United Kingdom.
Yes, I suspect this is perhaps a unique set of circumstances. I don't know whether we will see this sort of thing again where you have a situation where someone did appear virtually because of an issue around immunity and the fact that they weren't willing to come back to the jurisdiction. But throughout this, we have seen the British justice system willing to be flexible. And I think the family has been very grateful for that.
The most striking thing about a trial of somebody who's not in the country is that there's no way of enforcing a punishment if the person is convicted. And perhaps that's why the court passed a suspended sentence, knowing that if the conditions set by the court were not complied with, it would be very difficult to do anything about it.
Well, I think from the family's perspective, their focus was very much on the process and not on the outcome. They wanted her to face the British justice system, but they recognised that it's then in the hands of the judge as to what the appropriate sentence would be. And I can see that here, in the context, a suspended sentence navigated some of the challenges that would have arisen if they had needed to enforce a sentence against her.
More recently, we came on to the inquest process. And again, I think the family hoped that Anne Sacoolas would return to the United Kingdom. Is that your understanding?
That is correct. And certainly that had been the family's, given some of the indications that had been made, the family did have an expectation that she would participate in the process, either by returning or giving evidence virtually. And I think the family, as has been made clear, were extraordinarily disappointed that that didn't happen.
Could they really have expected her to return to the United Kingdom?
Well, the indication that we had from her lawyers at the pre-inquest review hearing in November was that she was willing to discuss participating remotely, and the coroner gave directions for that to be explored. We don't know whether it was her decision not to come back or whether she was encouraged not to by her employer.
Her employer being the US government?
Well, we know her employer, at least at the time of Harry's death, was the US State Department. We don't know her employer at the moment, but I know that in the criminal process, there was an intervention by the US government to prevent her from coming back to attend the sentencing hearing.
Do we know what she did for a living? I mean, you say she worked for the State Department, the equivalent of the Foreign Office in the United States. Do we know what she did?
All we know is that she was an analyst for the US State Department, and she explained in her police interview that she used a computer from the base to do her job.
She was working then at the time of the accident. It wasn't just that she was there as the wife of her husband who was working there?
She was, but she does explain in the police interview that her job was back home in the US. So I think she was working remotely from the UK for a job that actually remained US-based.
And Andrew, what do we know about this US base? I mean, it's officially a Royal Air Force base, but it's basically a little bit of the United States in Northamptonshire. Do we know what goes on there?
No, there is a certain degree of lack of information about that. And that was part of the challenge that I think the coroner faced in trying to get to the bottom of the key issue of what driver training was given to US personnel on the base. It is a bit of as you say, a funny status that although it's called RAF Croughton, it is in effect a US base with both US Air Force personnel and US State Department personnel present there.
It's a base. There are cars. They drive around within it. Do you know whether they drive on the left-hand side of the road or the right-hand side of the road?
That was one of our first questions. And actually, Tim, Harry's dad, knew the answer because Tim had previously worked as a postman, delivering letters to the base. So he knew that they drive on the left.
Same as in the UK?
Yeah, it's consistent.
I suppose it would be more understandable for Anne Sacoolas to set out on the wrong side of the road if she had been driving on the right, as you would have in the United States. But equally, anyone based here who drives in continental Europe must have had this terrible moment when you suddenly realize that you weren't thinking there are no landmarks and you set out on the wrong side of the road.
Well, I think that no landmarks point is one that was really explored at the inquest. We had quite a lot of evidence given by the council that at the time of the incident, there were no road signs that would have indicated to Mrs. Sacoolas that she needed to drive on the left. And those were actually put in place in October 2019, relatively shortly after the parents launched their campaign. We also know that there was a throwback arrow painted on the road, which Mrs. Sacoolas would have driven past, but she wasn't aware of it at the time, and she also hadn't received any training on the highway code. So one of the questions that the coroner explored was whether she actually had the requisite information to understand what that throwback arrow meant, and that it meant she should move back to the left.
And the coroner made a couple of recommendations, is that right?
She made 3. The first was one that actually emerged from the medical evidence on the first day of the inquest. This related to the fact that, very sadly, it emerged in the course of the inquest investigation that a paramedic manager had been stood down by EMAS, which is East Midlands Ambulance Service, the local ambulance service for our RAF Croughton. And so one of the issues that the coroner had to investigate was whether, had that paramedic manager arrived, they would have been the first resource and they would have reached Harry 24 minutes earlier than the other emergency personnel. And had they arrived 24 minutes earlier, would that have made any difference to the survivability of Harry's injuries? The medical evidence differed as to what impact that made, but one of the things that emerged very clearly from the evidence, particularly by a paramedic expert, was that had a paramedic manager arrived on their own without other medical resources to help them, they would have had a very challenging time moving Harry. He was lying on his front face down with a number of open fractures, and the first step in order to treat him would have been to roll him onto his back and then set the bones, and that was also contributing significantly to his blood loss. So in order to begin to treat him, they would have needed to give him very, very strong analgesia to be able to move him and then move the bones. Paramedic managers aren't entitled to carry strong painkillers. They can't carry diamorphine or fentanyl, as it is now the preferred drug. I don't think it was available at the time of Harry's death. But the paramedic expert gave very helpful evidence that actually those forms of pain relief would have been important in enabling a paramedic manager to treat Harry at a much earlier stage, which could then have had an impact on the survivability. So the coroner recommended that the Health and Social Care Department consider whether paramedics should be authorised to carry other forms of analgesia, and noted that actually there's an anomaly where mountain rescue services and the British military are permitted to carry other forms of analgesia, but not paramedics.
You mentioned 3 recommendations in all?
Yes, so the second was also related to emergency care, and this won't come as a surprise to anyone in the UK, but ambulance delays are a national issue, and in this instance also may have contributed to the length of time that it took an ambulance to reach Harry on the night. So the coroner has made a recommendation that the NHS look into ambulance delays, obviously there are many other voices on that subject already. And then the third recommendation related to driver training. So Andrew has mentioned that the coroner struggled to get information from the US about what driver training is currently being provided to members of the mission at RAF Croughton. And so she wants to satisfy herself, I understand, that there is adequate training in place. And so she's made that recommendation to the UK bodies that interface with the US, the America section of the FCDO and the MOD.
Andrew, that must have given some comfort to Harry's parents, the thought that some good might have come out of this tragic accident.
Yes, absolutely. And I think that has been their priority throughout this process, is to try and both find out really what happened, what were the reasons behind the tragic events that night, but also to try and, as you say, bring some good out of it by trying to address those underlying problems. And the recommendations made by the coroner certainly go some way to doing that.
Frances, you took part in the inquest.
Yes, I did. I was able to support Patrick Gibbs Casey, who was the family's barrister, in a kind of junior counsel role, which is very different to my normal day job. But I've worked with the family for a very long time, and being able to actually stand up and ask their questions of witnesses was just an incredibly moving experience.
But it's also very good training, Andrew, for people in this firm, or indeed all law firms who do this sort of work, because you're doing work you wouldn't do in the normal way of acting for commercial clients.
Absolutely. Not only the advocacy side, obviously we do advocacy in a lot in arbitrations and otherwise, but also stretching yourself a bit. I mean, an inquest like this is not, it would be fair to say, our day job, but I think it does need the same underlying legal analytical skills which we possess, and that does mean we can make a contribution, and hopefully a very valuable contribution, gathering the evidence, stress testing the evidence, and then in Frances's case, actually using that analysis to ask questions of witnesses.
And what about the trainees here and at firms like this? Do they get involved in pro bono work?
Oh, absolutely. And a number of trainees were involved in this case. I made reference earlier on to the global effort to do a review of how other countries approach the sort of immunity questions that arose during the judicial review. A number of legal issues arose during the course of both the judicial review, the criminal case, and the coroner's inquest. And so there were legal issues for the trainees to research. There's also more the administrative work, and we had a very good trainee support us during the course of the coroner's inquest.
And I should add, I actually first became involved as a trainee.
Did you?
I was on a secondment to our internal pro bono team and heard that this case had come in, and was lucky enough to be able to get involved, even though I wasn't actually sitting in the department with Andrew at the time.
And what's it like developing a relationship with these clients, the parents of Harry Dunn, because you must have got to know them very well over the years?
Yes. I mean, it's been a real privilege. They've impressed me at every turn with their dignity and their bravery, and they had to hear some very difficult evidence during the inquest. I think it's a different experience to working with corporate clients, because although Harry's family have actually now experienced quite a few different legal processes, they are not familiar with a lot of the underlying legal issues. A lot of the procedural issues have been challenging for them to understand, because obviously this has been a slow process, and we've had to explain to them why in some cases these things just take time, and that's been very difficult at times for them to hear.
And I think it's actually been a really good reminder that you shouldn't take for granted a client's understanding of the legal process. I mean, it was very obvious here that the family would never have been through this sort of experience before. And just trying to make sure that you're explaining at each stage what to expect next, because it's that lack of understanding of the process and a lack of appreciation of what what will happen, which can actually increase stress and anxiety. And in a different way, commercial clients sometimes have exactly the same issues. They need to understand what the process is and what to expect. So it's just more stark, I think, in this sort of example.
And it's not just that this is a unique set of facts. The diplomatic immunity, the fact that you had this trial in the absence of the defendant, the fact that you had all these complications, that was unique. Nobody has come across that before. But you're saying that there are broader lessons to be learnt when dealing with anything that's new to a client, whether a commercial client or a member of the public.
Yeah, absolutely. I think it's our job to act as navigators to the legal process for the client.
Because you assume that the commercial clients have been there before and they're doing these deals all the time, and mergers and acquisitions or whatever it may be. That's what they do. They're companies. They have staff who've done this before. And you assume they know what they're doing and they just tell you to get on with it.
Yes, and sometimes that's not the case. And it really is worth getting that reminder that whoever the client is, they don't like uncertainty. And just ensuring that you don't make the assumption that they know what will happen next. And I think that's actually this sort of case it just serves as a valuable reminder of that.
And Francis, you started on this case as a trainee. What lessons have you learnt from it that you're going to carry through to the rest of your career in the law?
A lot, in short. I think, as Andrew said, actually, it's been a baptism of fire in working directly with clients, particularly when I was a very junior lawyer and a newly qualified lawyer. You don't often get the same direct client contact when you're part of a big team on a fast-paced M&A dispute.
Mergers and acquisitions.
Exactly. But actually, in this instance, I have been one of the primary contacts for the family at A&O, so I've developed that relationship over the last 4 years, working with them almost on a weekly basis. And I think that trust that they have built up in us as a firm and with me is something that I will strive to replicate with all the clients I work with, hopefully in slightly less difficult circumstances.
Andrew Denny, Francis Beddoe, thank you both very much indeed. And that brings us to the end of this podcast, A Lawyer Talks. Many thanks to my producer, Neil Koenig. This was what we call an on-air pilot, a test run to see what works and how we can improve it. If you have any comments or suggestions, please put them in the comments box on my website, A Lawyer Writes. You can find it online. Just search for Rosenberg with a Z and Substack, all one word, and you should find it. As I've told my readers and listeners, I plan to start this podcast on a regular basis in the autumn. If you join my free mailing list, you'll be the first to know. Meanwhile, thank you for listening to A Lawyer Talks.